on the CINA 102.3 app, at CINAFM.com, on TuneIn, on Smart Speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس يأتيكم الآن على الهواء مباشرة. تحية طيبة لكم مستمعينا، أهلا وسهلا فيكم في حلقة جديدة من برنامج يور رايت مع المحامية جومانا كيروز، واللي راح تكون معنا بعد دقائق قليلة إن شاء الله. ودائما مكاتب المحامية جومانا كيروز تستقبل قضاياكم المختلفة، منها قضايا البيرسونال انجري، قضايا الكار اكسيدنتس، قضايا الهجرة والتجنس، قضايا الإفلاس، كريمينال لو، فاميلي لو، قضايا السوشيال سكيورتي وإصابات العمل. الاستشارة مجانية، رقم الهاتف 248-557-3645. حلقات برنامج يور رايتس يعاد بثها دائما على الموقع الإلكتروني yourrights.com/radio أو على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز. تحية طيبة لكم. حلقة اليوم مخصصة عن الإفلاس مع المحامي مايكل بنكستين. جومانا أهلا وسهلا بيكي، أكيد أرحب بيكي وأعرف يعني الطريق احيانا واحد يتاخر لكن وصلت اليوم اكزاكتلي على الوقت بالضبط. اهلا وسهلا بيكي جومانا في عبد الرئيسينا.
كتر خيرها لو وصلت على الوقت، بس I didn't take any shortcuts. تبعت على الطريق حتى لو جيت مؤخرة بيكون احسن من انه اعرض حالي او اعرض الاخرين لاي خطر.
النصيحة الذهبية دائما اللي تركزين عليها بالفعل انه واحد يوصل متاخر افضل مما يوصل نهائيا، لكن الاهم هي السلامة بكل الاحوال. بالفعل جومانا رحب بيكي مرة ثانية، حلقة جديدة واليوم مخصصة لموضوع الإفلاس.
صباح الخير كمان مرة لكل المستمعين. صباح الخير رامي، صباح الخير إلى المحامي مايكل بنكستين اللي صار له مدة قصيرة مش معنا، وإنما ابتداء من الأسبوع القادم نلتزم بجدول رح يكون ثابت كل يوم، اثنين، ثلاثة، أربعة، خميس وجمعة. Welcome Attorney Michael Benkstein.
Good afternoon, Joumana. Good afternoon, Rami.
How are you?
Good. How are you?
It's been a minute since you have been here. Before we start, can we share with the listeners, effective next week, you will be on the radio every single week on a very specific day. I want to say that our attorneys will try to stick to the times and the dates that is scheduled for them, but as you very well know, Rami, sometimes they have conflicts. They have to be somewhere where they cannot change the time. So in that event, and it will happen, it's going to happen, we will switch.
Sure.
However, effective next week, Attorney Michael Benkstein will be here every when is it, Attorney Michael Benkstein?
Tuesdays from noon to 1, Joumana.
Exactly. So every Tuesday from noon to 1, much like today, we will be going over bankruptcy. Every Wednesday, we will be going over car accidents or slip and fall or medical malpractice. Every Monday, of course, we do immigration. Every Thursday, we will doing social security disability as well as workman's compensation and or workman's compensation. And every Friday, we will be doing criminal and or family law. This is the schedule beginning next week because we will be on the air every single day. The times vary. On Monday, it's 2 to 3 p.m. On Tuesday, it is 12 to 1 p.m. On Wednesday, it is 1 to 2 p.m. On Thursday, it's again 12 to 1 p.m. And on Friday, it is 3 to 4 p.m. So it is kind of all over the place. Attorney Michael Benkstein, we welcome calls today, and the numbers to call are 313-769-6666, and from Windsor, 519-256-1023. Very quickly, can you remind our listeners, what do we charge for Chapter 7 bankruptcy? And then moving on to the fee waivers, and what does that mean? And who can enjoy and benefit from what we call a fee waiver, thus saving them an additional $335.
Thank you, Joumana. Our fees, our attorney fees for a Chapter 7 bankruptcy are $575. That's correct. We do file fee waivers for people who qualify for waiver of the filing fee to the court. That's different than our attorney fees. There is a $335 filing fee that you pay to the court when you file a bankruptcy. If you are within 150% of the federal poverty guidelines for your household size, you may be a good fit for waiver of the filing fee.
So very quickly, what we're saying here is when people need, or when someone needs to file for Chapter 7 bankruptcy, there is the charges of the attorney, because the attorney does not work for free, but there is also whether the court, the bankruptcy court, will require you to pay in order to file for bankruptcy. So the fee that we're talking about, or the waiver of the fee, that's not the attorney fee. That's a flat $575. It is rather the $335 that every bankruptcy court makes you pay, or else you will not be able to file for bankruptcy. And just to clarify that not everyone can, enjoy us asking the court to waive, meaning to take away that extra $335, meaning saving them $335. But if your income, and depending on how many people live with you and are dependents on you in your household, it has to be relatives of yours, dependents on you, not your friends or family members who are not dependent on you, but as your family, your own family. So depending on how much money you and or those who live with you in your household make, you may be able to qualify for that waiver and save yourself $335. In other words, that is, most people would pay $575 plus $335, plus there is the credit counseling 1 and 2, which is about $40 or $60.
It's $60 total for both of them.
Right, and then pulling the credit report.
That is $25 per debtor. So if you're filing as an individual, that's $25. If you're filing as a married couple, it's $25 a piece.
Okay. And those who can enjoy the fee waiver and save themselves the $335, meaning they only have to pay the $575 plus the credit counseling, which is $40, plus the credit report, which is another $25, are those people, when it's one person, if they make about 150% of $12,000, which is $18,000, and I'm rounding the numbers. For a household of 2, if they make $25,000 or less. For a household of 3, if they make $32,000 or less. For a household of 4, it is if they make $38,000 or less. For a household of 5, if they make $45,000 or less. For a household of 6, if they make $51,000 or less. And again, I am here just rounding the numbers. These are not the exact numbers. Thank you for this clarification.
You're welcome, Joumana.
Again, we welcome your calls, your questions, your comments about bankruptcy, Chapter 7, Chapter 11, any bankruptcy question that you may have. We have attorney Michael Benkstein for the full hour. The numbers to call are 313-769-6666 and 519-256-1023 for those who are listening and calling from Windsor. Speaking of people listening and calling from Windsor, bankruptcy law is a law that does not change from one state to the other, correct?
It's a federal law. There are certain exceptions. If you've lived in the state of Michigan for less than 2 years, there is something called exemptions or protections that you place on different types of property, and that's controlled by the state law of the state that you lived in for the last 2 years.
Okay. However, the federal code is the bankruptcy code is a federal law, and then there may be some state laws that apply.
That's correct.
So those who are listening from Windsor, assuming that they are Canadian residents who live in Windsor, what we're talking about does not apply to them. Am I correct?
That's correct. There may be some other insolvency legislation up in Canada that would apply to someone who lives in Canada, but generally bankruptcy law applies to people in the U.S.
We have also seen with Attorney Michael Roth, who is our guest from the Office on Social Security Disability, that there too there is federal law that applies wherever you live, but then there may be also some state restrictions, and we have talked about this on more than one occasion. And by the way, Rami, God willing, he will be with us this Thursday. We have seen also that for those who are relocating and they may be getting a certain amount in SSI, let's say in Michigan, they may be relocating to Ohio. Depending on Ohio law, they may end up getting a little bit less or a little bit more. So there is federal law, and there are some state restrictions that can help you or hinder you either way. Since we're talking about Social Security, let's talk about something that applies to a lot of people, because a number of our listeners have applied and do get SSI payments. And you have talked about the concept of commingling SSI payments from the state with other payments that go into your bank account. And God forbid, now you are, I take that back. I'm not going to say God forbid. I'm going to say, and now you are filing bankruptcy. God forbid, you think that your SSI payments are immune and that nobody can get them in a bankruptcy filing. And yes, you've heard this, and that's the general rule, but that's assuming that you've protected yourself and not mixed in the payments you get from the state with other payments that you have. Yes, you have to have under $2,000 at any point in time in your bank account, but maybe your Social Security payment, it's on average about $730, I think, nationwide. So you have plenty of room. You have another $1,250 for your daughter to give you money, for you to have had a certain benefit paid. And if you put it all in the same bank account, you are at risk of losing, if you file for bankruptcy, those payments as well. Am I correct?
Well, it's different depending on whether you're in the bankruptcy already or not. So when you're not in the bankruptcy, you don't yet have the benefit of what's known as the automatic stay. The automatic stay says that your creditors can't engage in any activities for purposes of collecting a debt. They can't call you, they can't write you, they can't sue you, they can't garnish you. Everything has to stop. What tends to happen is, if it takes a little while before someone's ready to file for bankruptcy, or if they're not sure if they're going to file for bankruptcy or not, if the only money that you have in your bank account is Social Security money, they can't garnish Social Security. The problem comes in, as you said, when you have other sources of income that are mixed in with the Social Security income in your bank account. Then what happens is, it loses its identity as Social Security money. So even though your creditor could not have garnished your Social Security funds directly, once it's commingled, then they can garnish your bank account. Although when you filed for bankruptcy, that automatic stay that goes into effect will mean typically that your creditors can't garnish that account. There is one very notable exception. Can I interrupt?
Sure. I will clarify. Thank you for the clarification before bankruptcy versus after bankruptcy when there is an automatic stay. However, if the Social Security money has been commingled prior to filing for bankruptcy, does that mean that after one files for bankruptcy, the bankruptcy trustee is also going to say, too bad you've commingled that money, so I'm going to also take the SSI income, or no?
No, because as I kind of touched upon a moment ago when I was talking about exemptions, although your Chapter 7 trustee does have an economic incentive in selling or liquidating assets for the benefit of creditors, there's certain amounts within which the trustee can't touch it. So there's different exemptions for motor vehicles, for different things like that. So he or she, if provided it was within the exemptions, wouldn't be able to touch the money even if it was commingled.
Okay, so then let's clarify. We are talking to those who are listening who get SSI payments or SSD payments as well. SSI, SSD.
It really doesn't matter whether it's SSI or SSD for bankruptcy purposes. They're
as
both
far as
treated.
the commingling rule, it doesn't matter.
Correct.
Okay, so what you are saying is, to those who are listening who have not filed for bankruptcy, who may never file for bankruptcy, but who may have outstanding debts out there, and they get sued by someone who now wants to garnish their bank account. If their bank account has SSI or SSD money and other money, they've commingled it, they've mixed it, it's a mumble jumble, it loses its identity, and now the person suing them, who does have a judgment, can garnish the SSI money. Allow me to translate this into Arabic because it's very important. However, you're saying once that person, and before they get a garnishment, if they decide to file for bankruptcy, then their SSI, SSD money is immune, and the bankruptcy trustee is not likely to touch that money, correct?
Correct, unless the creditor offset rule applies, which is something I do want to touch on briefly
So
after you've had a chance to translate.
Okay, so very good. Unless the creditor offset rule applies. Okay. عم نحكي عن في كتير من المستمعين بيحصلوا على SSI ولا بيحصلوا على SSD، وأغلبية المستمعين اللي بياخدوا SSI ولا SSD عندهم بانك أكاونت واحد. يعني بيحطوا المصاري ببانك أكاونت، ويمكن يجيهم مصدر مدخول من مكان آخر. طبعا اللي هو على SSI it's income based, it's need based، ما بيقدروا يحطوا بالبانك أكاونت تبعهم أكثر من $2,000 at any one point in time. بس إذا عم يحصلوا على $600 SSI، أو المعدل في الولايات المتحدة هالسنة كان تقريبا $730 إذا مش غلطانة، حتى لنقول عم يحصلوا على الماكسيموم SSI اللي هي $730 بالشهر. لنقول سلم جدلا عم يجيهم مصدر مصاري من مكان آخر تحت 2000، يعني they are safe، مش معرضين لخطر، لأنه دايما البالانس هي أقل من 2000. وإنما اللي بيقولوا المحامي مايكل بانكستين، مش عم نحكي بانكربسي، عم نحكي لأي شخص مش مقدم بانكربسي، أي شخص يمكن معرض لإقامة دعوة من قبل إنسان أو من قبل شركة. إذا هيدي الشركة حصلت على judgment ضده، بحق لها تعمل garnishment للبانك أكاونت وتحصل على المونثلي SSI payments تبعه. لأنه أغلبية المستمعين والأشخاص بالجالية بيفكروا correctly إنه مصاري ال SSI هي immune، هي فيها حصانة. الحصانة فقط إذا أنت حامية، الحصانة فقط إذا أنت مش دامجة مع payments بفوتوا على البانك أكاونت من مصادر أخرى. بس إذا حاطت البيمنت تبع ال SSI مع البيمنتس تبع ما بعرف، يمكن حادث سيارة بيجيك $400 payment مع شغلة تانية حتى لو دون 2000، إذا هذا الشخص اللي بيحصل على SSI payment وخابس الشغلة، ساعتها أي شخص بيقيم دعوة ضده أو مؤسسة بتقيم دعوة ضده، إذا وصلت لمكان صار في judgment، أمر، مش إقامة الدعوة، ربح الدعوة، الأمر، ساعتها بيقدروا يعملوا garnishment للبانك أكاونت، يعني يحطوا إيدهم على البانك أكاونت وعلى محتويات البانك أكاونت including اللي هي بتحوي كمان المونثلي payments تبع ال SSI. سو القاعدة العامة إنه ال SSI payments are immune تطبق فقط، عندهم حصانة تطبق فقط إذا نحن حاميين نفسنا وحاطين بس المصاري الاس اس اي بالبنك اكاونت. يعني شو النصيحه هون؟ النصيحه هون انه اي انسان عنده اس اس اي او اس اس دي يفتح اكثر من بنك اكاونت، وون بنك اكاونت يحط فيه فقط الاس اس اي اس اس دي بيمنت، والبنك اكاونت الثاني يحط فيه اي شيء اخر. وطبعا المفروض يكونوا الاثنين للاس اس اي اقل من سيبريت، بس بيكونوا الكومبايند لازم يكونوا اقل من $2000.
هل يحق له يكون عنده سيفنج ايضا بالبنك مثلا؟
Can I don't think it is a problem as long as it's the $2,000. SSI is need based. وبكره بنساله للمحامي مايك راث وبنتاكد. SSI is need based. يعني اذا عندك اكثر من اكاونت مش مفروض كل شيء بدك تفرجي انه انت، لانه الاس اس اي هي اصابه لاشخاص دون المدخول المعين واللي حكينا عنه رجع بنردده نهار الخميس. مين شو المدخول بده يكون لتقدر تقدم مع اس اس اي اذا عندك اصابه؟ نرجع بنرددهم. وانما بفتكر انا انه اذا عندك اكثر من one bank account، طالما the combination of whatever bank accounts saving checking and another saving another checking مش مفروض يتخطوا $2000 لانه it's need based. سو النصيحه هي هون انه للاشخاص اللي بياخدوا اس اس اي لحتى يكونوا حاميين حالهم بحال تعرضوا لاقامه دعوه وحدا ربح ضدهم، لحتى يضلوا الاس اس اي بيمنتس محصنين، انه يفتحوا بنك اكاونت فقط للاس اس اي. بيقول لي المحامي مايكل بانكستين وانما في إلها مثل كل قاعده عامه في إلها اكسبشن. الاكسبشن هي الكريديتور اوفست رول اللي هنحكي عنها بعد دقيقه. بس قبل ما نحكي عنها، لاي شخص عم يتسمى اذا بياخد اس اس اي حتى لو خالط الاشياء، هو بس معرض لخطر بحال حدا قام دعوه ضده، لا اكثر ولا اقل. بس هو مش معرض لخطر بحال قرر يقدم بانكربسي. اذا قدم بانكربسي حتى لو خالط الامور، الاس اس اي انكم محصن، والتراستي ما رح يعتبر انه الاس اس اي انكم هو اسset عنده اياه. سو هيدي شغله قصه الكومينجلينج هي قبل البانكربسي، هي ما بتطبق بالبانكربسي، وهي بس للاشخاص اللي بيحصلوا على اس اس اي واللي عم يخلطوا المصاري مع other income so it loses its identity، واللي ممكن يكون في حكم ضدهم مثلا اور كريدت كارد كمباني، يمكن عندهم حكم كريدت كارد كمباني بس ما بتحرز انه يقدموا بانكربسي. سو الكريدت كارد كمباني فيها تاخذ المصاري اذا طلعت حكم ضدهم اذا خالطين المصاري. Attorney Michael Benkstein, you said like every rule has an exception or two or more. That is, yes, SSI income when mixed with other sources of income in a bank account loses its identity and becomes vulnerable to a judgment by someone, except unless the creditor offset rule applies. Can you tell us what the creditor offset rule is?
Yes, Joumana. So most creditors, when they get notice of the bankruptcy, they have to just stop what they're doing.
Okay, so now we're talking about when those people file for bankruptcy.
Correct.
Okay.
So, you can think of it like a decision tree. So if it's just Social Security money in the bank account, then the creditors can't touch it. And it's kind of game over, at least as far as the Social Security funds in the bank account. If it's commingled, they could go after it unless you file for bankruptcy. Then the automatic stay means that they can't. But there's an exception to the stay. It's the creditor offset rule. If you owe money to a credit union that you have funds on deposit, all the other creditors, they get notice of the bankruptcy and they have to stop what they're doing. But that creditor would get notice of the bankruptcy and they can offset the funds in your bank account to pay themselves. Now, of course, if the funds are not commingled and it's just Social Security money, they can't do that. But if it's commingled, even if you filed for bankruptcy, if you owe money to a credit union and you have funds on deposit at that credit union, let's say you owe them $500 and you have $1,000 in your bank account and it's commingled, they could reach into that bank account and pay themselves that $500.
And that's for those who are commingling their money.
Correct. Yeah. If it's not commingled, then you don't even get that far, because even though it's an exception to the stay, even if there was no bankruptcy, your creditor wouldn't be able to touch that money if it was just Social Security money.
Okay, so the credit union. So number one, we're talking about people who have a credit union account. We're talking about people who get SSI or SSD. We're talking about people who commingled their funds, SSI, SSD payments with other funds. Now they file for bankruptcy. There is an automatic stay, meaning a freeze. Nobody can reach you, nobody can sue you, nobody can call you, nobody can take any money from your account. Unless you are dealing with a credit union, then they take priority, so to speak, and they can go into your account and get that money if they can show that you had mixed in that money with other monies.
Correct. If any one of those three things is missing, then that can't happen. So if it's a bank, not a credit union, you're fine. If it's a credit union, but you don't have funds on deposit, you're fine. You could have funds on deposit with a credit union, but not owe them any money.
Can you clarify what funds on deposit means?
Sure. So you have a checking account or a savings account, and you actually have money in that account. So let's say you had, credit union 123 that you owed money to, and you had funds on deposit in a bank account at credit union ABC. Unless you owe money to the credit union and you have funds on deposit at that credit union, they don't go into other accounts at other institutions and offset the money.
Okay, so we are about to translate this very important, although narrow rule to our listeners. Again, we are with attorney Michael Benkstein for the full hour. We're talking about bankruptcy. This is today's topic. Anyone who wishes to call or comment, the number to call is 313-769-6666 and 519-256-1023 from Windsor. So القاعدة العامة أنا رأيي النصيحة اللي بناخدها من هون إنه أي إنسان عنده SSI أو SSD يفتح أكتر من بانك أكاونت. بانك أكاونت بيحط فيه بس SSI SSD وبانك أكاونت تاني لأي شيء آخر، لأنه بيقول إنه الشخص اللي حاطط بالبنك اكاونت تبعه SSI SSD payments مع شيء تاني إذا قدم bankruptcy. سو هون في عدة شروط. هيدي القاعدة العامة إنه إذا قدم bankruptcy منه معرض لخطر حتى لو جامل البيمنتس قبل ما يقدم bankruptcy. وإنما لهيدول الأشخاص اللي بياخدوا SSI وكانوا خالطين المصاري مع غير مصاري وقدموا على bankruptcy وعندهم credit union، ساعتها الكريدت يونيون والكريدت يونيون فقط، البنك لا. الكريدت يونيون والكريدت يونيون فقط بحق لها تحط ايدها على المصاري لانه كانت ممزوجه. اذا كان هذا الشخص مش مازج المصاري، يعني لنقول مثلا شخص عنده 2 بانك اكاونتس، واحد بيحط فيه الاس اس اي بيمنت والثاني بيحط فيه اي شيء اخر وبيتعامل مع كريدت يونيون، الكريدت يونيون ما بحق لها تحط ايدها على المصاري اوتوماتيكلي، لانه عاده كقاعده عامه وقت الانسان بيقدم بانكربسي كل شيء بيفرز، كل شيء بيصير فروزن، ما حدا بيقدر يحكي مع حدا، ما حدا بيقدر ياخذ مصاري من حدا، ما حدا بيقدر يقيم دعوه على حدا لحتى to emerge out of bankruptcy، لحتى البانكربسي is discharged، الا الكريدت يونيون. يعني في يمكن قسم صغير من المستمعين بيتعاملوا مع كريدت يونيونز. جمال الكريدت يونيونز انه they are client owned، فمشان هيك الانترست ريت تبعهم بيكون اقل من البنكس. مش هيك في عالم بتحب تتعامل مع الكريدت يونيون، بس بعرف انه بالجالية ما في كتير اشخاص بيتعاملوا مع الكريدت يونيون، وانما لهؤلاء الاشخاص اللي بيتعاملوا مع كريدت يونيون وهن على اس اس اي كمان سبب تاني ليش ما لازم نمزج الاس اس اي payments او الاس اس دي payments مع اي payment اخر. Okay. I want to talk about the scenario that we get asked about all the time, husband and wife, and we've talked about it, but we don't repeat our shows here. So if people didn't hear us the first or second or third time, maybe some more will hear us today. Husband and wife, one wants to file bankruptcy and not the other. What's the answer? The question is always, I know my credit will be ruined because I am going to file for bankruptcy. Will anything happen to my husband? One. And two, or vice versa. And two, if we have a joint credit card, my liability will be discharged, but is he still or is she still on the hook for the other 50%? So if you have a $10,000 on a credit card and I'm the wife, you're the husband, my debt, which is supposed to be 50%, 5,000 is discharged. What happens to the other 5,000? Is my husband still on the hook? And will his credit score be affected?
Well, there are two ways to file a bankruptcy when you're a married couple, either as an individual, one or the other, or you could file jointly together. Let's say someone files as an individual. It's very important before someone files for bankruptcy to figure out, is all the debt in my name, or do I have some debt and my spouse has some debt? Or do we have any debts in common? Because a bankruptcy discharge will get rid of the debtor's obligation to pay, but not the obligation of a co-debtor who was not in the bankruptcy case.
Okay, so if I am on a credit card with my husband and I file for bankruptcy and the outstanding balance is $10,000, I am off the hook as to $5,000, but my husband's responsibility to pay the other $5,000 remains.
Well, if the entire
if I
amount,
file individually,
if the entire amount is $10,000 and you're both equally obligated on the $10,000, your obligation to pay the $10,000 would be gone, but your husband would still be obliged to pay the $10,000.
The whole $10,000.
Correct. You are co-debtors. You don't get to wipe out part of it.
Okay, that's very important. Thank you. I knew that. I should have remembered. Okay, so for those who are listening, who are interested in filing individually, when the wife wants to file individually or the husband wants to file individually, on any common debt, I can foresee credit cards being, and mortgage. Both of your names are on a mortgage, correct? For your home.
Yes. I mean, but if you're keeping the house, if you're not filing for bankruptcy because of the house, let's say that the husband and the wife are both on the mortgage, but the husband has, I don't know, $30,000 worth of credit card debt. The wife doesn't have any credit card debt. He could file as an individual, Chapter 7, eliminate that debt. Of course, you wouldn't be able to get rid of the debt on the mortgage, but keep the house. Like if they want to keep the house, they'd have to keep paying on it. But she's not looking to eliminate her responsibility to pay the mortgage, because if they're keeping the house, they can continue to pay the mortgage and keep the house even though he files for bankruptcy.
Okay. And generally speaking, can you give a general opinion about the benefits of filing? Who would best benefit from filing jointly as a husband and a wife, and who would best benefit from filing individually, thus preserving somebody else's credit?
If all the debt is in one person's name, all of the debt that you're seeking to eliminate, then it makes sense to file the bankruptcy, on behalf of the person who has all the debt in their name. If there's any significant amount of debt in both of their names, or even if they don't have any debts together in common, but they each have a pile of debt, as it were, it makes sense to file jointly and eliminate the debt.
Can you give us examples of joint debts that a husband and a wife typically have?
Yes, they might both be on the credit cards, and the balances are $25,000 or $30,000.
Okay. Both names are on there. What else?
That's a good example. If they were both on a mortgage and the mortgage was foreclosed, and they're coming in after a foreclosure, but in the state of Michigan, if there's a foreclosure but the mortgage company is still owed money, they can come after you for the deficiency.
Any other debt, joint debt?
Yes, tax debt. Certain types of tax debt, not all types of tax debt, but certain types of tax debt are dischargeable in bankruptcy. So if you both have tax debt that can be eliminated in a Chapter 7 bankruptcy, it would make sense for you to file jointly.
اوكي رامي، عم نحكي عن سيناريو دايما نحن بنسمع عنه وبنسأل عنه بالمكتب، السيناريو عن رجل وامرأة متزوجين وعم بيفكروا يقدموا بانكربسي. السؤال هو هل شخص من الشخصين بيقدم بانكربسي أو هل الشخصين بيقدم بانكربسي؟ وإذا شخص من الشخصين قدم بانكربسي شو مسؤولية الطرف الآخر بهيدا الحالة؟ ما فينا نقول كقاعدة عامة هل لازم الإنسان يقدم as an individual، يعني لنقول المرأة أو الرجل، أو هل لازم الشخصين يقدموا. طبعا وقت الإنسان بيقدم بانكربسي الكريدت سكور تبعه بده ينزل بالأخص أول سنتين. اذا الكابل قدم بانكربسي الشخصين الكريدت سكور تبعهم نزل. مش هيك دائما في امل انه طرف من الطرفين يقدم لحتى الطرف الاخر يضل الكريدت سكور تبعه جيد. بس بهيدي الحاله ما بيعني انه الطرف الاخر مسؤوليته راحت، بالعكس بعد مسؤوليته 100%. لنقول رجل وامراه عندهم كريدت كارد $10,000، الكريدت كارد باسم الاثنين. اذا الرجل او الامراه، الرجل قدم البانكربسي مسؤوليته على 10,000 راحت، it is discharge، عفيوا عنا. بس بما انه هي اسمها على الكريدت كارد $10,000 كلها بعد مسؤوليتها. so the decision، القرار انه نقدم joint ولا نقدم separate، هيدي بتختلف من سيناريو الى الاخر حسب شو الدين اللي نحن بدنا نتخلص منه. في ديون بنحب نتخلص منها مثل الكريدت كارد، بس في ديون مثلا نقول مورجج على بيت ما عليه فوركلوجر، بدنا نقدم بانكربسي بس بدنا نحافظ على البيت، هيدا ديت باسم الاثنين ما بدنا نتخلص منه. كمان مرة أغلبية الأوقات الشخص من الشخصين بيحب يقدم لحتى يساعد الشخص الآخر بالعلاقة يحافظ على الكريدت سكور تبعه، وإنما هيدا ما بيعني إنه مسؤوليات الطرف الآخر راحت، لأنه الإعفاء بيكون فقط ليلي بيقدم بانكربسي. الزوجة بتقدم الإعفاء إلها فقط، وإنما هو بعده مسؤوليته 100% لأي شيء that is joint. typically joint بيكون the mortgage، typically joint بيكون credit cards. وبيقول في بعض التاكس debts، في بعض المسؤولية على اثنين إذا راحت مسؤوليتها المسؤولية عليه، وفي اشياء cannot be discharged in bankruptcy. دايما نحن بنحكي انه نقدم بانكربسي هي حل لاشياء مثل كريدت كاردز، بس تقدم بانكربسي يمكن ما تعفيك عن الستودنت لونز تبعك، يمكن ما تعفيك عن التاكسز that you owe to the government, to the IRS, to the state والى اخره. عم نحكي قاعدة عامة، يعني في ديون حتى لو قدمت بانكربسي تقديم البانكربسي مش رح يعفيك عن المسؤولية. واحدة منهم هي certain tax debts. Thank you, Attorney Michael Benkstein. Again, do you want to add anything?
There is one thing I wanted to add about one little nuance to whether someone files as an individual or jointly, is that even if you're filing as an individual, the court still wants to look to the income and expenses for you and your spouse, even if your spouse is not filing for bankruptcy. So if you have income and your non-filing spouse has income, the court still wants to know what their income is, and that goes to whether or not you're eligible for a Chapter 7 bankruptcy. The one exception to that being if you're separated, if you're not living in the same household.
By the way, to those who are listening who may be considering filing for bankruptcy and who are going or maybe going through a divorce, I think it's very important to consult with a family law attorney who consults with a bankruptcy attorney, or with a bank, whichever comes first, or with a bank, whichever decision comes first on your part, or with a bankruptcy attorney who will then consult with a family law attorney. Can you briefly tell the listeners why two attorneys in two areas of the law need to be talking?
It's so important to coordinate these issues because sometimes it makes sense to file the bankruptcy first, get the debts resolved, and then file for divorce. There's other times where it's the complete opposite, where you'd want to do the divorce first, and then after the divorce was concluded to file for bankruptcy. One of the many great things about our firm is that we have a number of attorneys, each of whom specialize in a different practice area. So we could handle that in-house, the divorce and the bankruptcy, and coordinate it quite closely to get you the outcome that you're looking for.
Can you give us specific examples of, or one specific example where you've consulted with a person or a couple who is considering divorce and bankruptcy, and you've advised them file and get out of bankruptcy first and then file for divorce, or just file and then file for divorce, file bankruptcy and then file for divorce?
Yes, I can give you an example. So if there's a number of debts for both the husband and the wife, if they do the divorce first, sometimes the divorce court, the family court, will allocate the debt to one party or another to a degree. If that gets baked into the judgment of divorce, as it were, that becomes a domestic support obligation. So, and then that's not dischargeable in a Chapter 7 bankruptcy, for example. So literally, someone could have filed the bankruptcy first, eliminated the debt, and then never had to pay that, and then file the divorce.
What about an example of where it's better to go through the divorce proceedings first and then file for bankruptcy?
A good example of that is if sometimes you have one party or another that just doesn't care that you've got to file for bankruptcy. There may even be a case where on paper it's optimal for you to file the bankruptcy first, but if the other party simply doesn't want to go along with that, sometimes you can't always control events. Sometimes it makes sense to file the divorce first. For example, let's say that you have a husband and wife whose combined income is such that the person who needs to file for bankruptcy wouldn't qualify for a Chapter 7 bankruptcy. Now, I'm not saying you'd ever divorce just to qualify for a Chapter 7 bankruptcy, but if you're headed towards divorce anyway, and then you're divorced, the divorce has concluded, now you're not living in the same household, now you're not married, so now the court's only looking at your income and expenses, and whereas maybe 6 months or a year ago you wouldn't have qualified for a Chapter 7 bankruptcy because your non-filing spouse's income put you over the limit, now you do qualify for a Chapter 7 bankruptcy, and then you're in and out in less than 6 months and get rid of your debt.
Michael, when you say file and then file, are you saying file and finish and then file? So when you say sometimes it's better to file for bankruptcy and then divorce, file and then get discharged from bankruptcy and then file for divorce?
Oh, yes. I mean,
or have two pending matters at the same time? No.
I mean to say, generally it's a good idea, particularly in the context of a Chapter 7 bankruptcy, which is such a short process. Obviously, it's totally different in a Chapter 13 repayment plan where you're in the bankruptcy case for a 3 to 5 year repayment period. That's a bit different. But, you know, in your sort of your typical Chapter 7 6 months or less process, it would generally be a good idea to handle those things in one sequence, to do the one and then do the other.
اوكي رامي، عم نحكي عن كمان ظروف بنشوفها عنا بالمكتب بتصير مع كثير اشخاص متزوجين عم بيفكروا بالطلاق، وبذات الوقت حالتهم المادية صعبة كتير، وعم بيفكروا كمان بالبانكربسي. على فكرة مثل ما بنقول the number one reason للعالم بيقدموا بانكربسي هي medical bills that they cannot, that are due, that they cannot afford. كمان الدراسات بتقول انه number one reason for divorces are financial. ومين اللي بيقدم bankruptcy? Financial. So you see how there is an interplay between, you know, being tight on money and having family problems and then filing for bankruptcy and so forth. وقت لي الشخص عم بيفكر انه يقدم bankruptcy وبذات الوقت عم بيفكر انه يطلق، من الضروري جدا يتكلم مع محامي. لو مين ما كان المحامي لازم يتكلم مع محامي اخر بالاختصاص الثاني. يعني اذا شخص اجى بده يقدم bankruptcy وعم بيفكر بالطلاق، لازم المحامي تبع البانكربسي يحكي مع المحامي تبع الطلاق بذات الوقت، لانه يمكن القرار يكون طلاق بالاول bankruptcy second، او العكس يمكن يكون bankruptcy first الطلاق second. سو من الضروري جدا للاشخاص اللي لا سمح الله عم بيفكروا يطلقوا وبذات الوقت عم بيفكروا يقدموا bankruptcy to coordinate بين محاميين من ال two specialties، لأنه the order in which you do it may help you a lot. يمكن financially أحسن لك تقدم bankruptcy وتطلع من البانكربسي ومحو كل هالديون، بيصير طلاقك أسهل بكتير. ويمكن أوقات العكس، تقدم الطلاق وتخلص من الطلاق وبعدين تقدم بالبانكربسي. خلاصة الموضوع هون إنه لهدول الأشخاص they have to consult with both family law attorneys and bankruptcy attorneys, because the order in which they file and get through something may matter, may make things a lot simpler and a lot cheaper. Bankruptcy first, then divorce, or a divorce first and then bankruptcy. And again, we are talking with attorney Michael Benkstein. To those who want to listen to this show again, they can go to the Joumana Kayrouz YouTube channel. And by the way, if you subscribe, every time we download a a tape, you will get it there. And if you want to know what was talked about briefly, you can click on the opening. It will give you bullet points of the most important points we talked about. So this way you can decide for yourself, do you want to listen to this tape or not? Likewise, they are present on our yourrights.com website under Your Rights/radio, correct, Michael?
Yes, I believe it's yourrights.com/radio. And of course, yes, also on YouTube.
Michael, we have about 9 minutes remaining. What was your blog? You write a weekly blog. You and all the other lawyers and all the other specialties write weekly blogs and download them on the website or upload them to the website. Do you remember what was your last weekly blog? I'm happy to pull it out if you wanted.
Give me just one moment.
Not a problem. Because correct me if I'm wrong, but you do try to write about things you encounter in the office, people who call repeatedly about a certain issue, common misperceptions, common misunderstandings, things that you believe are worth really talking about, correct?
Yes.
Okay. And while you're looking, I'm going to pull it out, and I bet you I'm going to be faster than you. There we go. Here we go. And your what happens if a creditor keeps garnishing me after I have filed for bankruptcy? Correct?
That's correct.
So what is that about? I filed for bankruptcy. I've had debts. I have been sued by a credit card company, and they have a judgment against me, and they garnished me the first time, and then I rushed to file LA for bankruptcy, and there goes the second payment.
Yes, sometimes a creditor continues to garnish you after your bankruptcy is filed, even though by law
they shouldn't be.
They're not supposed to do that.
Mm-hmm.
Any funds a creditor garnishes you after you file for bankruptcy must be returned to you in full.
Okay. Another blog article that you wrote about the week prior to that is, will I lose my property? Will I lose my possessions? Will I lose my clothes? Will I lose my my furnishings? Will I lose my car if I file for bankruptcy?
That's correct. There are a number of exemptions or protections that you can place on property. In the state of Michigan, so long as you've lived in Michigan for at least the last 2 years, you can decide whether you want to use the Michigan exemptions or the federal exemptions. The federal exemptions are generally more generous in terms of things like cash on hand, money in bank accounts, but they're a little bit less generous in terms of the amount of the equity in your real estate that you can protect. The Michigan exemptions are the opposite. They're more generous in terms of the equity you can protect in your real estate, but there's other things that you can't protect using the Michigan exemption. So it really matters a lot what your facts are.
The blog you wrote the week before, we just touched upon, if I'm married and need to file for bankruptcy, does my spouse have to be in the bankruptcy too? The blog you wrote about before that is avoid accumulating debt. This is a piece of advice you're giving people. So we'll finish on that note. We have about 5 more minutes. Avoid accumulating debt within 90 days of filing for bankruptcy. Why are you giving people that piece of advice?
I'm giving people that piece of advice because your creditors do have the ability to object to discharge if they have a basis for doing so. There's only a few bases for objecting to discharge, but one of them is if you accumulated debt in anticipation of filing for bankruptcy. And that's commonly understood to be if you accumulate debt within less than 90 days prior to filing for bankruptcy.
Is that like I'm starting my diet on Monday, so let me eat and eat and eat and eat and eat this weekend? Because I'm going to start on Monday, my diet.
Yes, I've absolutely had people come into the office and I say, when's the last time you used your credit cards?
Yesterday.
Yesterday. Oh, okay. How much do you think you've used on your credit cards in the last 90 days? Oh, $3,000 or $4,000. Then my advice is, 1, stop using the credit cards right now. And then 2, let's put something on the calendar about 3 months
from now.
3 months and 3 days from now, where we actually file, so you get beyond that 90-day period.
So it makes perfect sense to provide to prevent abuses of the bankruptcy laws If you are rushing to put all that debt because you think that once you file bankruptcy, it will all be wiped out, it makes sense that you shouldn't rush to do that. So you have to wait another 3 months where you've been pretty much clean of incurring debt, because you are at risk. And again, repeat what the risk. If I'm a credit card company and I see that you've used my credit card and put $3,000 in the past 1 month because you know you'll be filing for bankruptcy, and you think the whole $10,000, including the $3,000 you just put on, will be all wiped out, so you might as well put it on a credit card and enjoy that, then what am I likely to be able to do once you file for bankruptcy? I may convince the trustee to keep that $3,000 out of what can be wiped out?
Yes. It significantly is greater chance that your creditor is going to object to discharge if you accumulated debt with them within less than 90 days.
And when you say a creditor whose credit card you used and abused to great excess a day before you file bankruptcy is objecting to discharge, what does that mean in lay terms?
What that means is, so you have a Chapter 7 bankruptcy. You do all the things you need to do. You go to your hearing. But then there's a notice period. After your hearing, there's a 60-day notice period where any one of your creditors could object to discharge. Now, it doesn't object to your discharge in total. It's just that creditor saying, I don't think my debts should be discharged, the amount owed to me.
Okay,
and they have to have a reason for that.
And what does a judge typically say then?
Well, that's why it's so important not to accumulate debt within the last 90 days, because if you did that and that creditor objects to discharge, when the court is deciding whether or not that debt should be discharged, the court is required to presume or assume that the debt is non-dischargeable unless you're able to prove otherwise. A very difficult standard to meet.
So I don't understand. Does that mean that, let's say I put $2,000 on my credit card yesterday. So what does that mean? I will be able to file for bankruptcy and get discharged, but that $2,000 is one of my assets? Considered an asset?
It's not that it's an asset. It's the question is whether or not the debt should be eliminated as a matter of law. It may very well be that if you accumulated a bunch of debt before you file for bankruptcy, very shortly before you file for bankruptcy, it's very likely that that creditor is going to object to discharge. It's very likely that the judge is going to grant that exception to discharge, and then you could get out of bankruptcy and still owe thousands of dollars.
Okay.
So timing is very important.
Very important clarification, and I don't think we've talked about it very clearly in the past. رامي في أشخاص يمكن بيفكروا بدي أقدم bankruptcy خليني to max out on my credit cards لأنه بكرة بدي أقدم bankruptcy وبده انعفى عن كل هيدول الديون. الظاهر إنه الديون اللي بحطها إنسان بده يقدم على bankruptcy آخر 90 نهار، يعني آخر 3 شهور قبل ما يقدم بbankruptcy، يمكن يعرضوه لخطر. بيقدر يقدم bankruptcy، بس إذا صاحب الدين عمل objection يعني عارض، لأنه مثل كأنك عم تستغل الظروف، مثل كأنك
كان سابق نية إنه راح يقدم على
نية، عارف خليني تو ماكس اوت افري كريدت كارد لاخر دقيقه لاخر لحظه، لانه بعرف انه بالقانون في الولايات المتحده بقدر انعفى عن الدين. اي دين بينحط اخر 3 شهور قبل تقديم البانكربسي يمكن يكون الانسان من بعد ما يقدم البانكربسي ويطلع منها مجبور يردهم. يعني انا عم فكر خليني بعد عندي $4,000 فيني احطهم على الكريدت كارد، لانه بكره بدي اقدم بانكربسي، بحطهم على الكريدت كارد، بقدم بكره بانكربسي، بنعفى عن كل الديون ما عدا $4,000. يعني معناتها رح يطلعوا من جيبتي. بيقول كقاعدة عامة وكتب بلوك عليها avoid قد ما بيقدر الإنسان، قد ما بيقدر avoid، تحاشى إنك تستعمل ديون أو تحط ديون آخر 30 نهار قبل ما تقدم بانكربسي. شو النصيحة اللي بيقولها للموكلين اللي بيجوا لعنا؟ إذا أنتوا عاملين ديون آخر جمعة وجمعتين وكم يوم وشهر، خلينا ننتظر 90 نهار إضافيين. ليه لنقدم هلأ؟ لأنه يمكن الكريديتور يعارض ويمكن تقدم بانكربسي بس ما تنعفى عن هيدول الديون اللي حطيتهم آخر 3 أشهر. بدك تكون نضيف على 3 أشهر، ما تزيد دين على 3 أشهر لتقدر تستفيد من القانون، لحتى إذا نطرنا 3 أشهر وقدمنا ساعتها عن جد all your debts will be discharged.
بالفعل. نصائح كثير مهمة ورائعة بنفس الوقت. إن شاء الله يعني مثل ما ذكرت راح يكون التركيز أيضا والحديث تقريبا أسبوعيا عن موضوع الإفلاس
كل نهار ثلاثة
كل يوم
بإذن الله.
الثلاثاء إن شاء الله.
نعم.
شكرا لك جمانة على وقتك، وإن شاء الله نلتقيك في
نهار
حلقة
الخميس
مقبلة إن شاء الله.
مع المحامي مايكل روث، اختصاصي Social Security Disability.
إن شاء الله. Thank you, Mike.
Thank you,
Thank you.
Michael.